Lexmark sells printers. They sell printers to sell ink. Now, they're not the only company that uses this business model, and that's probably why I commonly hear that ounce per ounce, printer ink is worth more than gold. I don't know if that's actually true, but it's somehow believable. Because OEM printer cartridges are so expensive, people look for cheaper alternatives. This is what created the refill market, and it turns out to be pretty lucrative. That also impacts Lexmark's bottom line. At least they seem to think so. Lexmark tried to find a way to stop this. In 2004, they tried using copyright to block third-party cartridges. In 2014, they tried using trademark law. Both previous attempts were struck down by the Supreme Court. So Lexmark filed a patent infringement suit against a company that sold refilled cartridges. The case made its way all the way back up to the Supreme Court, where all 8 judges of the Supreme Court ruled in favor of the refill company. Citing the first sale doctrine, the ruling states that once a company has sold a product under patent law, they don't have any right to dictate how that product is used or disposed of. Kind of seems like a common sense thing. You buy something, you expect to be able to do whatever you want with it, or what you need with it. Commonly, the first question most people have is, what effects will it have on other industries? The question I find more compelling is, how does this affect us, the consumers? The Supreme Court ruling means that you have the right to repair, modify, or resell the items that you have purchased. A manufacturer can't sue someone for patent infringement because they repair a product. Now, some people may think this will have no effect on me. I don't do any repairs, I'm not handy with tools, I'm not interested in doing that kind of thing, and I'm not going to hack my stuff. Okay, then you might want to think about how that affects repair shops. The ruling protects more than the individual's right to repair. It also avoids some serious economic damage. Justice John Roberts used auto repair as an example. Really, it applies to any repair service. Computer, cell phones, household appliances. This could also include some parts of the refurbished market as well as the used market. Without this protection, the cost of getting something repaired would rise, because the only people doing repairs would be the manufacturers. The extra steps a third-party repair service would have to take to avoid legal issues would be too costly to be affordable to customers, or even profitable for the service company. That would result in the loss of jobs, and no, they wouldn't end up working for the manufacturer's repair department. There is a theory that if Lexmark had won the case, consumer goods would balloon in price, because the same legal process to stop repairs could be used to stop the sale of used items. A market without cheaper options would be forced to support higher prices. This could also create a barrier to technology and some standards of living for lower income families, not only shrinking the middle class, but also making economic inequality even greater. In theory. But like the ink is worth more than gold, it's somehow believable. The ruling holds the status quo, which in this case is a good thing. It's worth noting that companies that want to limit what people do with the items they buy still have other options to do so. There is contract law and license agreements for software. It's why tractor hacking is a thing. John Deere is using DMCA to prevent farmers from repairing their own tractors. and it could be a violation of copyright law to simply remove the part of the engine control firmware that prevents the tractor from starting after repair work has been done. The DMCA firmware issue affects more than just tractors. It also applies to things like TVs. Much like the Samsung TV that can be remotely hacked into for eavesdropping, disabling the microphone could be a DMCA violation. There are other appliances to be considered about. Kitchen appliances, cell phones, tablets, networking hardware, cameras, the list goes on and on. All of them can or do have software that can be a threat to privacy, property, and productivity. And the way the license for the firmware or software is written, you might be breaking the law by removing those threats or restrictions. The most recent Lexmark ruling has ended a major threat to consumer rights. But like I said before, there are still other ways that consumers and owners might lose their rights to companies who want to limit us for their profits. The best course of action to preserve our rights is to write our local representatives and tell them to support right to repair. Thanks for watching, and good luck. To subscribe, click the channel icon on the top left. Top right is the previous video, and below that is a random suggestion from YouTube. Thanks again.